All right, welcome everyone to the fourth Abolition University session sponsored by Virginians for Alternatives to the Death Penalty. And today we're going to be focusing on the absolutely crucial role of capital defense attorneys in the movement to end capital punishment in the United States. And we have an amazing panel to be with you today. And we are really privileged to have Henderson Hill kicking us off to give a national perspective. Henderson has had a long career in the capital defense community. He is currently the senior counsel of the Capital Punishment Project of the American Civil Liberties Union. And prior to that, he was the founding director of the Eighth Amendment Project, which is the overriding strategy organization of the abolition movement, and has been absolutely key within the movement for many, many years. He's also worked as a public defender in North Carolina and founded the Center for Death Penalty Litigation in Durham. And he also had a crucial role in the Racial Justice Act in North Carolina. And there was recently a state Supreme Court decision allowing all those who had submitted an appeal of their death sentences under that law to go forward. And so Henderson is an amazing guy. We were really privileged to have him as our keynote speaker at our annual awards luncheon several years ago. And so welcome, Henderson. The floor is yours.
Good morning. Thank you, Michael. It's a pleasure to be with you and with this group. You know, when we first talked about having this webinar, we were still in the throes of the country's wrestling with the pandemic and wrestling with the issues of racial equity and police accountability. And it's hard for me to think of any part of the justice system today without sort of grounding the conversation in the historical moment that we're at. And I think lawyers and advocates have played a special role in sort of getting us to where we are, where the country is, to examine the legacy of racial terrorism, of racism, and how that interplay with the criminal justice system impacts our clients. My practice, my capital practice has been almost exclusively grounded in North Carolina. And as a lawyer in North Carolina, as an advocate in North Carolina, I have stood on the shoulders of some giant lawyers, Julius Chambers, Adam Stein, Jim Ferguson. These were lawyers at the Ferguson-Stein firm, Ferguson-Stein Chambers firm that advocated for racial equity back in the 60s, who challenged police killings of unarmed Black men back in the 60s and 70s, who challenged the imposition of the death penalty as a continuation of the lynching culture that had grabbed hold and dominated the justice system in the South all throughout Jim Crow and all throughout the 20th century. So that's sort of the platform on which my litigation, capital litigation, was built in 1990. And when I think back about the role of lawyers, they are both in getting us closer to abolition. I think of a couple of things. One is that it takes courage to engage the community, the court, in this conversation about race and our country and our state's sort of shameful legacy with respect to the treatment of African American citizens. And it's that courage that has emboldened lawyers to file and to litigate aggressively Batson motions for nearly 30 years. And the case that you just sort of recently mentioned, the half dozen cases that argued before the North Carolina Supreme Court under the Racial Justice Act was the culmination of a decade of legislative campaign activity, followed by a rigorous academic study, followed by 7 or 8 years of creative litigation. And it culminated in a 6-1 decision that found that the General Assembly's repeal of the Racial Justice Act was a violation of the state constitution. That decision and the litigation that made that decision possible now puts us in a position of litigating 140 claims of resentencing. That puts us in the position of requiring district attorneys and the attorney general to think again whether the investment in the death penalty is worth the cost, both the budgetary costs and the opportunity costs for better uses of resources to promote public safety. When I think about the question, the broader question about lawyers' role in abolition, I'm driven back to observations that Justice Ruth Bader Ginsburg made shortly after the Glossop decision. Some months after that, she gave 2 talks, public talks to various law schools. And in those public talks, she mentioned that she shared her confidence that abolition was on its way. It was more a question of when as opposed to whether. But what she also acknowledged was the how piece of it is that abolition was likely to come as a result of attrition. That is, the use of the death penalty would be so diminished that we basically take the vigor out of this old relic of a punishment. And what led her to that observation was the drastic decline in death sentences throughout the traditional death penalty. And I think, Michael, you and other panelists being based in Virginia are eyewitnesses to the truth of Justice Ginsburg's observation. I can recall when I first got into the Capitol community, Virginia was killing folks at a rate that outpaced every other state in the country. While it had a relatively modest size or even small row, you were killing humans at an unconscionable rate. We now look at that row, and if I'm not mistaken, you've got no more than 2 people on the row, and maybe not even that number. And the thought that Virginia's row could be that small, that the role of the death penalty in the criminal justice system could be that insignificant it's miraculous for anyone that's been around for as long as I have. On this panel, I think Jerry Zirkin may be the only person who's been around longer than I. And I remember the time, the Jerry Zirkin era, when the battle was whether we'd ever have a institutional defender organization, either federal or state court. Now we look at what these institutional officers have done. And Ed, my God, these institutional offices basically strangled the death penalty in the state of Virginia. It's made it nearly impossible to get a death sentence in the state of Virginia. I wake up to the news that Commonwealth attorneys or district attorneys in Virginia are signing on to petitions to repeal the death penalty in the Commonwealth. These are some historical moves that were just sort of unthought of 2-3 decades ago when I first started to be engaged in capital work. When I think about Marie Deans and the work that she did, just trying to stick fingers in the dike in the opposition to executions and to the death penalty, be in really the commanding position we are now. It's both a blessing, and it's an example of what concentrated effort by advocates and by the legal profession, by the defender community, has made possible. And if that's possible in Virginia, it could be done, almost everywhere else. Because when you go from Virginia down the East Coast to North Carolina, South Carolina, Georgia, we see the same dynamic in place. And in the same way that the defender organizations that have basically reduced the death penalty to an almost nullity in Virginia, the role of the organized defender bar in North Carolina, in Georgia, is also as clear. So I think that there are many paths. There are several paths to abolition. Many of those paths lead through the efforts of advocates and lawyers that are fighting this fight in legislatures as well as the courtroom. As part of the ACLU, I've been privileged to work with a group of lawyers in the state of Kansas. You don't get much deeper red than Kansas. But in Kansas, they newly discovered Article 1 of the state constitution. And in that Article 1, which is very similar to the Article 1 in the North Carolina Constitution, it promises protection of life, liberty, and the pursuit of happiness. Well, their state court read that protection of liberty to have real protection for a woman's right to choose in the context of reproductive rights. And shortly after that ruling, lawyers representing death row inmates said, well, let's take a look at this Article 1. Article 1 not only protects liberty interests, but life itself. And the state's death penalty policy infringes upon that fundamental right, a fundamental right that's protected by the state constitution. And the court should take briefing on this. And the state Supreme Court agreed and invited litigation at the district court level, and for that litigation to bubble up to the state Supreme Court. We've got a state Supreme Court in Kansas that has a remarkable record of scrutinizing both the basis under the state and the federal constitution of death sentences. Up until recently, every death sentence had been reversed, at least the first time around, by the state Supreme Court. So we have some confidence that the state of Kansas will take a serious look as to whether the death penalty is still something that is consistent with the state constitution. And Michael, I hate to filibuster, but it's hard to think that we can leave this discussion about the role of lawyers in helping to advance abolition without noting what happened just a year or so ago in the state of Washington. After conducting a rigorous study on the role of race in that criminal justice system, the court found that the death penalty was arbitrary. And arbitrary in a way that's inconsistent with the state constitution. The court looked specifically at the role of jury discrimination, the ineffectiveness of the Batson claim, promulgated a rule, general rule, that breathes new life into the protection of every citizen's right to the franchise, that is, to the ability to sit on jurors. That kind of advocacy, which ended the death penalty in Washington, stands as a model for litigation elsewhere in the country. So I guess the principle I'm saying is whether you're looking at Virginia and the Commonwealth attorneys and the new challenges they're waging at the penalty, or as far away as Kansas or Washington or North Carolina, what you're finding is creative ways in which the death penalty can and should be attacked under both state and federal constitutions. And I think that shines brightly as a beacon of hope for what we can accomplish in the next couple of years.
Thank you, Henderson. I appreciate your terrific insights into today's conversation. Before we move on to the panelists, I should have mentioned this up top, but every attorney that's working in this field and all the policy advocates out there, like we at VADP, are in a sense singing off the same hymn sheet, a clear national strategy. And that strategy has two tracks. One is the policy one, trying to end the death penalty through the legislatures, through public education, through media work. And the other is in the courts. And an important part of that is, as Henderson said, is driving down the number of death sentences and challenging in the appellate process those death sentences that are still being imposed. And the panelists that I'm going to be introducing are some of the attorneys who are responsible for the fact that Virginia has 0 death sentences in nearly over 9 years now. And the folks on this panel are a big part of why we've gotten to that point. And the first panelist is one that Henderson mentioned, Jerry Zirkin, who is been practicing since 1978 and has been working on death penalty cases almost from the very beginning of his legal career. He was part of the team that represented Earl Washington, an intellectually disabled man sentenced to death who was later exonerated through the use of DNA evidence. Jerry is also, another of his high-profile clients was in a federal death penalty trial, that of Zacharias Moussaoui, one of the Al-Qaeda plotters of 9/11. And Jerry's got a remarkable legal career and is going to be speaking to us about his experiences, excuse me, about his experiences of prosecutor misconduct in the legal process. So Jerry, I believe I've unmuted you, so you should be on.
Well, thank you very much, Michael. You know, as Henderson said, I've been around for, and you said it doing my biography, I've been around for a long time. And one of the things I learned from being around that long is that you shouldn't follow someone like Henderson Hill. But so be it. And let me say, in his defense, that that Mr. Moussaoui was many things, but it was only the government's conception of reality that he actually was one of the plotters of 9/11. But regardless, he did receive a life sentence, yeah. So I'm going to talk about prosecutorial misconduct as it relates to the death penalty. And the sort of underlying principle is that the higher the stakes in a case, the more serious the case, the more likely there is to be prosecutorial misconduct. That is, you are unlikely or less likely to see misconduct in a, petty theft case or a grand larceny case than you are to see it in a homicide, and particularly a capital case. And the reason for that is pretty clear. That is that the more severe the case, the greater the political stakes involved, especially where you have elected prosecutors, such as we have in Virginia. So the greater the political stakes are in the result of that case, and therefore the greater, from the prosecutor's standpoint, the greater the need for and the justification for breaking the rules in order to obtain a conviction and a death sentence. And we know that, in fact, on a basic level, the death penalty is sought very often, not because the particular case is particularly demanding of it, that is so much more severe than others, but because for whatever reason the political climate in the jurisdiction at that time in relation to that case urges the prosecutor to seek the death penalty. And so with various political incentives at play, the prosecutor has ample reason to cut corners and sometimes to bulldozer over the rolls if that will assist in obtaining a conviction and a death sentence. So to give us a little bit of a background, prosecutorial misconduct can come in many different forms. And I'm going to talk about two really. One is what is typically called Brady Violations, named after the case that sort of set the standard for it. And that is the prosecutor's duty to turn over exculpatory information to the defense that is in the possession of the prosecution. And those cases have evolved over time defining what those are. But basically the prosecutorial team is investigators that are involved in the case, other prosecutorial agencies that are involved in the case, and the prosecutor is responsible for the knowledge of those various agents within the prosecutorial team. And the duty of the prosecutor is, in fact, to discover the exculpatory information that's in their collective possession and to disclose that at a meaningful time to the defense. Now, that can be in the form of evidence that we would think would tend to exonerate the defendant directly. Does it mean that it has to be evidence which shows that the defendant was on Mars at the time of the crime was committed? It can simply be something that undermines some piece of the prosecution's case or what it has to prove. And it includes what we call impeachment evidence. That is evidence that, for example, one of the prosecution's witnesses has given inconsistent statements at other times. All of that is within the scope of the kind of evidence the prosecution has to turn over. Now, the problem is that it's left to the prosecutor. Nobody is supervising what the prosecutor turns over. It's in very rare instances in which the judge gets involved in determining whether or not something is exculpatory evidence. Sometimes a prosecutor will go to the judge with that, but very rarely. I don't know that I've ever seen it in any one of my cases. So it's left to the good faith of the prosecutor to determine what he or she should be turning over to the defense. So we've had some egregious examples of violations of the rule in Virginia in capital cases. I think one of the most egregious is a recent one of Justin Wolf in Manassas in Prince William County, where the prosecutor, Paul Ebert, had a policy to not disclose exculpatory information unless he determined that that information was true. It's really supposed to be up to the jury to decide what's true, not up to the prosecutor, but Mr. Ebert had a different view of it. His view was that because he'd had experiences in which defense attorneys fabricated, his words, fabricated defenses based upon information he turned over, that he wouldn't turn over evidence unless he determined that that information was in fact truthful. The Wolf case went up and down to the Fourth Circuit, went through habeas, went up and down between district court and the Fourth Circuit a number of times. And it would be fair to say that the Fourth Circuit excoriated him. It's one of the most blistering opinions about a participant in the legal system that I've ever seen, and I think that any of you would ever have seen. And Ebert wasn't shy about it. It was his policy. He said it, he adopted it, he confessed it, he didn't see any problem with it. Now, one of the things that was involved in that case, and we find it in many other cases, and I'll tell you, it happens in far more cases than we ever discover it in, is the phenomenon of coaching witnesses and not disclosing to the defense the coaching that has been done. So that a witness is fed information, that a witness is, that the testimony is molded by the prosecutors to fit the testimony of other witnesses, to fit the forensic evidence that's available, so that the prosecution's case is as seamless as possible. And that's one of the violations that occurred egregiously in the Justin Wolf case. Now, in some jurisdictions, and the Fourth Circuit is one of the courts that applies this rule, the Brady rule doesn't apply. The duty to turn, that is, you can't win a claim based on the failure to turn over exculpatory evidence if the court determines that defense counsel could have found the information themselves. So that creates this enormous escape hatch for the courts to not find the prosecution liable for Brady violations. I had a case a number of years ago of a defendant named Ronald Hoke out of Petersburg, had a case which was, I will say, tried from the beginning of jury selection until the death sentence verdict in one day. And in Mr. Hoke's case, it involved the predicate for the capital charge was a rape. There were some unusual aspects to the sexual act involved. The police had done an apartment by apartment search, doing an investigation and trying to find out information about the victim, and including her other sexual conduct. And they found out some information that was clearly would have been beneficial to the defense. And it was not turned over. Ultimately, Mr. Hoke's case, I got involved in the federal habeas proceeding, and we luckily were able to obtain the police file. We discovered all of that information. And in the final analysis, we won in the district court. In the final analysis, we lost in the Fourth Circuit because the court determined that the defense counsel could have found the information himself. Now, the police found the information by going door to door and literally threatening people to get them to confess. People didn't want to talk because it involved their having extramarital relationships with this woman who was the victim. They didn't want to give up the information. The police threatened to get it, and yet the Fourth Circuit ultimately decided the defense counsel could have found it himself. It was an absurd conclusion, but it gave them the escape hatch to not give Mr. Hoke relief, and he ultimately was executed. Now,
thanks, Jerry. You know, I'm just seeing the time is sort of going by. If you have a closing before we move on.
yeah, not a specific remark. Let me just say that the other aspect of it is also prosecutors standing by and allowing false testimony to happen and not correct it, and that also is a violation. And all of this implicates the testimony of prosecutors using snitches and not revealing the deals that are made with stitches and the benefits that they are getting.
Thanks so much, Jerry. We appreciate your the benefit of your long experience in trial as a trial attorney. Our next panelist is Ed Ungvarsky, and Ed has been a criminal defense attorney for 25 years. He's currently in private practice, but spent 12 years as a trial attorney with the Washington, D.C. Public Defender Service, and he led the Northern Virginia Capital Defender Office for many years. And that office was responsible for representing those accused of capital murder at trial. And before trial courts, Ed and his team successfully kept 13 clients from receiving death sentences. And so Ed's been a terrific friend and supporter of VADP for many years, and we are very grateful that he's with us today. I just unmuted you, Ed, so you should be on.
Okay, great. Well, thank you. Well, I'm thrilled you can hear me, so I'm thrilled to be here this afternoon. Thank you for inviting me. And before I talk about relationships with clients and the family, I do want to touch about issues of race. I started out doing this work in the early 1990s as a law student. I applied to work for both Jerry Zirkin and Henderson Hill. And so they were already leaders in the community. I had the opportunity as a law student to intern with Brian Stevenson at an organization which is now EJI. And I also worked with Steve Bright at the Southern Center for Human Rights. And the value of those experiences for me was it put race front and center in this work from when I was young. And so it's always been sort of a core part of how I've seen capital punishment and the death penalty and the criminal legal system. And one of the cases that we did at the Northern Virginia Capital Defender, we were researching the history of lynchings in the county, in Loudoun County, including that the last recorded lynching was within the last 100 years at the local high school, and that the grounds of the courthouse was a situs for public lynchings in the past. And it seemed like we were moving toward another one of those, but in a courtroom. So, when doing this work, I came to it from being a public defender, and it's very important for lawyers to have strong relationships with their clients. I was taught the phrase client-centered work, and at the DC Public Defender Service, where Henderson had been, that's sort of the core of the work, is the client comes first in every way. And when I went to do full-time capital trial work, I had done habeas as a young lawyer, but capital trial work, I really, the idea of putting the humanity and the dignity of the client up front and center was so important, because that's what would save his or her life. I was asked actually to address race, and I just want to say two things about race. First is, of the approximately 20 clients that I've had at the pretrial stage as capital defendants, 70% have been people of color. And I, you just see that as like, that's more likely to end up being a client. And then the really sad and cynical reality. Part of my job at the Capital Defender Office was to look at murders that occurred within my jurisdiction and think, is this a case in which they may seek the death penalty? try to get into the case early. And what was so sad to me was one of the ways in which I informally would suss out whether I thought they were seeking the death penalty is I would look to see what are the race of the victims. If the race of the victims were people of color, if the victims were young African-American men or African-Americans or Latinos, I knew there was a much less, a decreased chance that that prosecutor was going to seek the death penalty, and that was a case that probably wasn't going to be coming to me, and I may not try to have to intercede early. And that was sad and cynical, and it is the harsh reality of the practice. Race permeates every aspect of the capital system. All right, so I have about 2 to 3 minutes left because I really want to stick to the short end of the time. So at the end of all this, you can ask questions through Michael and then Henderson, and we'll talk more. So, because hopefully you'll ask, and he'll get back on. The idea of, human dignity of the client, it's so important for a lawyer to develop a relationship with the client and have the whole team develop a relationship with the client and see them as the powerful, vital human being that they are, and to have it be an honest relationship. Capital Defender Office, we try to see our clients twice a week for, anywhere from 1 to 3 hours each visit. Some clients we saw more often than that. Very rarely did we see a client with less frequency than that. And we tried to see them and develop a positive human relationship. What that meant for me was to be open and honest about who I was, to be genuine in who I was, not to try to front and pretend I was someone else or have some connection maybe that I didn't have, but to see who I was and to learn who he was or she was. And when you do that with any human being, you realize that you have things in common, and there are things that you both love, or you recognize that they love. So I'm going to tell one story because I'm at 5 minutes and I wanted to stay under 7. I want to stay at 6. I represented a client who was 19 years old, African-American, who did really, really violent, vicious action that led him to be charged with capital murder. And how to relate to him. He grew up in a very different environment than I did. And one way we related was we played chess. And in playing chess, what was really important was he beat me. Not that he beat me because I let him beat me. He beat me because he beat me. He was better. Now, eventually I upped my game, so I stopped that. But it was really valuable that he could beat me, and he saw that. It was also really valuable that I saw how smart and capable he was. And so we came up with a curriculum. I got 1 minute left. We came up with a curriculum for him to read. And so we would buy him books, and we bought him Black Boy by Richard Wright, shorter than Native Son. And he would read that book, and he understood it. He could see his life. And it was so sad for those of us who are on the team to think that that client was sitting in a jail where he was likely to spend the rest of his life in a cell, in a cage, when he should be in college. And then if his life had started differently, and if there had been different paths, different turnoffs, he would have been in college right then and not on his way to a lifetime in a cage. And so I was really honored to have gotten to know him and to have gotten to have a relationship with him and to have learned from him. And that's one aspect of the power of working with a client. And then I'll just add, and through it all, we're also developing relationships with the family members, and that's really important. But I want to stop here because I know we're running short on time.
Thank you, Ed. We could go on for hours, but at least this gives a flavor of that crucial aspect of capital defense work. So thank you so much. Our final panelist is Kristina Leslie. And Kristina is currently serving as an assistant federal public defender. She's also worked with the Capital Defender Office in Northern Virginia with Ed Ungvarsky. And she was also a public defender in Baltimore City for 4 years. She also happens to be the president of the VADP Board of Directors. So we're very, very pleased to have her on the call. And as soon as I find her, I will unmute her, and you're on, Kristina.
Thank you, Michael, and thank you, everyone. I'm so excited about this large audience. My first Zoom call with more than 4 people. So this is exciting. So as Michael's shared with you all, for my entire career, I've been a public defender, representing clients on the front lines. And it really wasn't until I got involved with VADP that I saw other ways of advocacy that defense attorneys should also employ. And so what I've been tasked with speaking with you all about today is the role of a capital defense attorney engaging with the legislative process and how that can help bring about abolition. It is undeniable. Right now, our country is having very serious conversations. It's been a long time coming, but very serious conversations about criminal justice reform. And we as defense attorneys, we simply can't be asleep at the wheel at this time. We need to seize this opportunity and be a voice in the room to ensure that the decisions that are being made and the policies that are developed that will undoubtedly impact our clients and the communities they come from. I'm a resident of Fairfax County, Virginia, and I've sat in a couple criminal justice panels. And one thing that I have noticed is that the speakers that are on those panels, there's always a representative from the police department. There's always a prosecutor. There's always a local legislator, but it's very rare that I see someone of the defense bar who is there once again representing the people that will be deeply impacted by these laws. We're still feeling the impact of the crime bills from the 90s that vastly expanded the federal death penalty, made it even more difficult for people with death sentences to get relief, and exponentially increased our prison population. That experience to me is just a prudent reminder of how important it is that for me as a defense attorney, while yes, I'm obviously advocating for my client today, but I need to be also focused on tomorrow and all the other people that get encapsulated in this system. Now, here in Virginia, many of our colleagues on the defense bar have really done a wonderful job collaborating with people like Michael Stone and our organization, VADP, to help bring about change and move towards abolition. Folks have provided legislative testimony before the General Assembly, and others have played more of a background scene as far as drafting legislation, weighing in on how certain provisions may impact our clients. One person in particular that comes to mind is Douglas Ramser, who is the former defender out of the Richmond office, who really spearheaded the movement in the Commonwealth to bring about discovery reform. Jerry talked about prosecutorial misconduct and how there has been a long history of a lack of transparency and accountability with the government, both in the Commonwealth as well as other jurisdictions. And now that we have this discovery bill that's just going to open up so much more for the defense community and provide an additional check to hopefully mitigate against future prosecutorial misconduct in cases where the ultimate is on the line, whether or not your client will live or die. We've also seen a lot of collaboration within the Capitol defense community, as well as other advocates for abolition with respect to the severe mental illness bill that Senator Favela introduced in this past General Assembly that got a lot of traction, which is huge. Again, to kind of echo some of the comments that Henderson made earlier, like we're talking about the state of Virginia in the South, that we're able to have this sort of momentum happening, which is just so exciting. Additionally, there was an abolition bill that was presented to the General Assembly in 2020 that, again, got a lot of traction and kind of laid the groundwork for when we reintroduced that bill in 2021, coupled with the fact that there hasn't been a new death sentence since 2011, coupled with the fact that we only have 2 people left on our death row. Again, as attorneys defending cases on the front lines, it kind of gives us a unique perspective to see how certain laws would be interpreted by the courts and actually have an impact on the clients who we're trying to protect. So it is so vital and important that we play an active role in the legislative process. Thank you.
Thanks, Christina. Actually, we have a question I think that you may want to handle given what you were just speaking about. One of our participants sent in the chat feature a question. We have a local public defender in Portsmouth who's alleged to have participated in defacing the Confederate monument last weekend. Do public defenders typically participate in protests and other political, societal actions in Virginia and elsewhere?
Sure. Do you want me to answer that, or?
Why don't you start, and then we can open it up to the others on the panel.
Well, this public defender certainly does. I can't speak for all of them, but I know last Friday, I think it was last Friday, unfortunately I couldn't participate because I do have a young one at home that I need to watch for. There was a national public defender march in light of all the events that we're all well aware of that have been going on. But if I may also kind of, because again, Michael, I know you asked us to address race in the work. One thing that I would like to kind of talk about that I think dovetails with that question is, like Ed, I was also trained by people like Ed, who have been amazing in that race and issues of social justice have always been at the forefront of their practice and have always been a part of the work. Also, as a Black woman, like race is something that I deal with daily, right? And so even though I have been trained and worked with colleagues that adopt this mentality, within the last 5 years, I've attended conferences where I'm seated during lunch with other attorneys that have talked about their clients. I've heard the disparaging words and the demeaning adjectives that they use to describe their clients of color. I've heard them talk about the countries that they've come from. And I mean, this is problematic for several reasons. One, these are the comments that someone is saying at a table where I'm sitting, which really makes you wonder what other conversations are happening when I'm not there, right? But also, in a capital context, making this especially troubling is this defense attorney who is describing his client in that way is charged with saving that person's life. So if that person or that team fails to even see the humanity or think that his life even matters, how on earth is he supposed to convince a prosecutor or a judge or a jury that their client's life has value? One of the leading factors that lands a defendant on death row is having an ineffective assistance of counsel, is having an incompetent attorney defending your case. And so it really, when I was in that moment, listening to him listen to that attorney speak about his client, I wondered if his client was white like him, would he still be making these sort of comments? And then I had to ask myself, when I represent someone who was white versus a person of color, am I defending a little bit harder for my white clients versus my Black or Latino clients? I mean, unconscious bias, implicit bias is something also that is now making its way into the mainstream that we all have to deal with. But particularly when we're defending these cases where our clients' lives are on the lines, I think it is so imperative that we are thinking about race, that we are staffing our teams in culturally competent ways to ensure that we're not missing issues that could get our client killed. And again, I don't want to take up too much of the time, but one very specific example of how being culturally competent can save your client's life involves assessing or investigating intellectual disability. For example, for those of you that are not aware, if you are able to prove that your client is intellectually disabled, they are per se ineligible for the death penalty. But what we're finding with our Spanish-speaking clients, where there's a language barrier between either the defense team or the expert that's performing that assessment, a lot of times these experts are adding on points to their IQ score to kind of compensate for the language barrier. Oh, well, maybe this person doesn't understand it because English is not their first language, which then puts you in a situation where you have someone who very possibly could be intellectually disabled and therefore ineligible for the death penalty, is now being prejudiced because of their heritage and different language, which could result in that person living or dying. And so I guess it's a very roundabout way of saying, yes, I think for some people like me who feel called to do this work, it goes beyond just representing this case, this client. We're talking about human rights. And so I think it's very important to participate in protests if that's something that speaks to you personally.
Thank you so much, Kristina. And I'll just add one comment is that whenever we're organizing testimony at the General Assembly on any issue, whether it be the severe mental illness exemption, whether it be on abolition, we always try to have a capital defense attorney as part of the team that's testifying, because you all bring real world experience to the testimony. You can give examples of how this plays out in the courtroom with your clients. And I know Jerry has done that before, and we've had other capital defense attorneys who have spoken very powerfully before legislators and have a lot of credibility in the eyes of legislators because of their experience in the courtroom. We have one other question that I'm going to open it up to any of the panelists to respond to. One of our participants asked about resources for capital defense, and are the big law firms still involved in death penalty cases? They often have wealth contacts and lots of political contacts. Are they still involved? And if so, is that a net plus in terms of their cases? So I'll open it up to any of the panelists who might want to respond to that.
Well, Michael, I'd say initially that some of the big law firms, there was a time early on in the death penalty process where big law firms in Virginia absolutely refused to get involved in capital cases. I mean, and it was something that we litigated in Giarratano v. Murray, and they just said no. Then they became very much involved, and really were able to make some really serious contributions. My sense is that their participation is substantially diminished now, in part because we have a Capital Resource Center helping with habeas cases, which is where their focus really was. They weren't doing cases at trial, they were doing habeas cases. We have a Capital Resource Center, and that has resulted, I think, in fewer of the big law firms participating. And I don't think that they participate much. Ed may have different experience with that at the trial level. I mean, I can't remember a big firm actually taking on a capital case at the trial level.
Yeah, I think I would chime in just to give the more of a national perspective, because I think, as Jerry says, the institutional offices that have taken over Virginia they've kicked butt. There hasn't been a need for the big law to take on that responsibility. However, if you go to other parts of the country, Texas, Mississippi, Arizona, we're still looking and calling on large firms, their resources, their talent pool to get involved. Remarkably, there are a handful of the major law firms that have self-standing pro bono departments. And when one of those law firms get involved and takes on a capital case, you see litigation like you've never seen before. These are law firms that are willing to work with substantive experts like Ed and others, so that you have not only the size and the resources, but you have them working in a strategic and informed way. And when they're willing to put their credibility behind the litigation, it makes a difference and it saves lives.
Thank you so much, Henderson. And it is now 1 o'clock, and we had promised to wrap this up at 1 o'clock. But I will give the panelists one last time for a closing word before we end. Anyone? Jerry, Ed, Kristina, Henderson?
I'll just circle to give a shout out to Ashley Parrish, who's a lawyer at a big firm in Richmond. I do think that big firm lawyers have a huge value and they contribute a lot to the legal work against the death penalty across the nation. A little less here in Virginia now than in other places because the need is less here than other places. But Ashley Parrish led the litigation in the Eastern District of Virginia in the Fourth Circuit in the Justin Wolf case. And I mean, there are other lawyers on that case who are my friends, and I never met Ashley Parrish until the case came back to Prince William County Circuit Court, but he was the leader of that work. And his firm just knocked that thing out. And so they are really, really valuable. And I think the value of having advocates, social justice advocates outside the courtroom and advocates working inside the courtroom, working together has contributed to the driving down of capital cases in Virginia. And I think it's what's going to contribute to its abolition within the next 12 months. So thank you very much for asking me to be here.
I just have one comment really, and that is the lack of consequences that results, that produces misconduct on behalf of prosecutors and poor performance on behalf of by some defense counsel. But with prosecutors, the difficulty is that the Virginia State Bar simply won't take any action against them. Paul Ebert or bar complaints, they refuse to do anything. And so there are no consequences. If they're caught cheating, all that happens is they get a retrial. And so they're without any real disincentive to break the rules, they're free to do so.
All right. I think that will be our last word. Thank you again to the panelists, and thank you to all the participants for joining us today. Hope everyone has an outstanding day, and the recording of this will go onto the VADP website within the next week or two. So stay tuned for that if you want to revisit this. And again, thank you so much and have a great day.
Thank you.